We're live.
Senate Education Committee back after a short break. And we have back S227. This is the Sanctuary Schools Bill, call it, that we passed out. The House has now done a strike all. It's actually been on the calendar, so we wanted to go through and fully understand what changes the House made. So it's always a little harder when it's a strike all, but council knows where the big changes are and can hopefully explain those to us.
Hopefully.
You're on.
Yes. So Rick Sagel with the Office of Legislative Counsel. And in preparation for this, I knew you might have me in. So I made a side-by-side that is on the web page. You can website and access.
We have hard copies.
And Mr. Chair, if it's okay, I just asked Stephanie to send Representative Arsenault the Zoom link because she went to go pick up her child and otherwise she'd be in here and I figured that was easier as well.
Okay.
Okay. So 227 is the immigration protocols in schools that was passed by the Senate several weeks ago, came back from the House as the chair said, a strike all. I have highlighted the pertinent changes from the House version to what you all passed. So on the left side of the screen is what you all passed. On the right side is the House proposal of amendment. So section, I'll just go in chronological order. Section 1, to purpose, no changes. The purpose statement. Section 2, a few changes here. You will see frequently the addition of the term head of school or designee occasionally. And there was actually, this kind of goes on throughout the bill, that I think unintentionally parts of the bill did not apply to independent schools, just to public schools. So there's occasionally the addition of head of school to indicate that this is meant to also apply to independent schools as well. Okay, on the definition of non-public area of the school, the Senate version, again, on the, getting confused, on the left side, did not have the language that the House added, which was includes an area that a superintendent or head of school or designee determines to be non-public. The committee had a pretty robust discussion about this, and there was debate about what if the high school gym teacher indicates that this is a non-public area, and there's maybe disagreement with the principal or the superintendent. So the House version kind of narrows it to, it has to be a superintendent, head of school, or someone they designate to determine that a portion of the school is non-public. That's the change there. So instead of just any area of a school, has to be those administrators have to make that decision.
I actually hesitate to ask this question, but is it possible that the area could be non-public some of the time, most of the time, and then sometimes be public?
So the definition, yes, would allow that administrator to make that determination. Yep.
Okay.
The definition of school was amended a little bit, and this is mostly because the way we use the word school throughout the bill, the way it was changed. In the House version, on the Senate version on the left side, school is a public school or independent school and includes employees, independent contractors, and school resource and safety officers working for the school. The House version removed those individuals. And just as the House took the bill, it became clear that using that term school to include people became problematic. And I'll explain as we go on how that showed up and how we fixed it in the House side. Okay, on to page 2, subsection B, the immigration resources. This was changed. It looks much more different than it actually substantively is. I'll explain what happened. But in general, most of the provisions that came out of the Senate are still in the House, just restructured a little bit. So a superintendent or head of school, the House adds or head of school, as independent schools would also be required to do this. Distribute immigration resource guide developed by the AG to staff, students, and family members of students. You see the Senate side on the left. The phrase "and civil rights related" was removed. So just specific to immigration. And then B.
Approved independent schools, does that mean approved independent schools? Are we telling all independent schools, even if they're not approved?
No, so the definition under school on page 1 of the side by side, they must be approved under section 166 Title 16.
And is that
The
can
wor-
we tell independent schools if they're not approved by the state? I mean, they can't operate, or?
This may be a best thing Tim's question. To my knowledge, there is a process that a independent school gets approved by the state. And I don't know why that's done, but there is some process that an independent school can take, which it's still independent, but it's in an approved status as according to the state. And again, this is maybe a best thing Tim's question.
I think it's kind of a word order, that's all. We're just not used to seeing it as independent schools approved under section 166. We always see it as approved independent schools. We never reference the section 166. I think it's just a word order issue. I mean, the word order is fine, but I think it may have initially confused Good Center.
So I guess my question then is, do we have independent schools operating in the state of Vermont that are not approved? And do we have jurisdiction over them?
So probably a question I can't answer. I can ask.
They don't get tuition. Yeah.
So it sounds like that is a legally important distinction. So if they're not approved, then yes, they would not have to abide by these state laws, this specific state.
So we need to put approved in front of independent schools.
Well, the word approved is after independent schools. They're approved under section 166.
Whatever.
I think the language is okay. I think that's okay. Maybe worded differently, but I think it's
That's the same thing.
yes. Back to subsection B, immigration resources. Again, you have a couple of instances of adding header school to sending out this information, still provided by the AG, no change there. Subdivision C on the House side is similar to subdivision 3 on the Senate side. Language is mixed around a little bit, but importantly, on the Senate side, you had that the guardian is detained by immigration authorities. This was more about just a student. If there's a student immigration issue, it could involve their guardian being detained, but it's not written that way. So in some ways, it's broader. It allows that immigration connection to apply to any type of student issue, as long as it's related to the student or the student's family. But you can compare the two sets of paragraphs there. There are some language differences. The immigration resource guide in the Senate version was in session law, and there was a discussion about that is an ongoing.
Just to avoid backtracking too far, if I could, Mr. Chair. So paragraph C in the House version, connecting the student, connecting is a pretty soft term. And I just want to look at my colleagues and see if that's an acceptable term before we move on. And then I also would like to recommend that the words "and the student's family," I don't think the superintendent has any responsibility to the student's family in this case, that it's really about the student when we're talking about the superintendent themselves. Kind of widens the aperture. What if they take care of the student, but the student's family is, not located, they've gone into hiding, whatever, the worst case scenario might be. The superintendent by this language still is responsible for connecting them to an immigration advocate. And I'm not sure that's appropriate.
I have some thoughts, but
Yeah.
and I didn't ask House Education, about this exact change. I could send a message to Representative Brady and get a sense, but there's two thoughts I have about why I think it's a good change. Number one, there will be some kids who are too young to have this conversation. if they are, I mean, there's best practices, of course. Those best practices probably go out the window, but certainly elementary school level, you're going to want to have, you don't really have contact with students about any parenting or legal matters, you're going to be talking to the family. And two, that's exactly what happened in the case of South Burlington. It might not always be at the superintendent level, but it very much should be somebody who reports directly to the superintendent. And in the case of what happened in South Burlington, it was, I believe, their kind of equity outreach director of the district who reports to the superintendent, because that person probably needs to get an okay from the superintendent to be involved in the way that they were, which was to remove very young children from out of the house, and coordinate to have a guardian waiting outside. So whether or not we like it, I don't want this bill to have to exist, but it does, and this is a practical matter.
I'm wondering, in the bill we just did yesterday on the floor, the chronic absenteeism bill, we tried to be specific. And the word family can mean a lot of things. And if they're not, I wonder if it's guardian or family or parent or guardian is what we really don't want to say. And I wonder why they dropped, and maybe why did they drop the part about including a situation where it's where the guardian has been. Wow, what is the difference between it looks like there's a lot of difference between our 3 and their C. Or am I missing something?
The immigration advocacy institution it's restructured. It's there. The word foster's gone, but it's.
Why don't we noodle on it, and I'll ask Erin if they are okay with parent or legal guardian, which that might be the language when I was in elementary school, but it is true that if they are going to be, they should, maybe based on my experience with the South Burlington situation, for the school to get involved in helping facilitate transfer to a standby guardian, they should be doing something to make sure that person has standby guardianship and that they're not.
And of course, that was what we did last year. It came out of the Judiciary Committee for the preemptive.
Right. So maybe even if they haven't made it to court to do that, or whatever the process is, they haven't that.
Is this only during a school year, a school time, when this can happen? I mean, like if it happened midsummer and the student gets broken away from their parent because does the superintendent step in then?
Well, I think it can depend because in the situation that unfolded before our eyes, ICE went to a family's home across the street from all 3 of the schools. And there were children who attend those schools inside the house. So it was during school hours, but it was not on school property.
Right, so I don't see how does the school even get involved in that?
Because everybody.
Well, the language is
inside.
the language is to the extent possible, and it would be as long as it's a student. So the summer they would still be a student, right? But again, the language is fairly squishy, and it's up to probably each unique situation of how the superintendent or head of school will handle it.
I understand the purpose and I like the purpose, but I don't understand how a superintendent could come in and say, oh, I gotta find parent or guardians for these child that school's not even in session, but now I'm gonna become.
And what relieves them of that obligation?
So what makes them have that obligation?
It starts to, I don't remember it off the top of my head, but further on in the bill, it starts to refer to the school premises and, you know, on-site and non-public areas of the
That I
school.
get.
And so, you know, there are, you know, schools are used when school isn't, you know, during the regular school year. So you've got summer camps, daycare, sports.
I agree with all that. But when you're off in school grounds, what authority does a superintendent have? In this case, but I'm asking you, Senator Hinsdale, that what real authority, if any, do they have to be able to do this?
I think what you're seeing from all the news reports is that literally no one in that environment had any real authority. Period. Not ICE, not anybody. So when children are endangered and there is a school official nearby, I think we should err on the side of allowing them to have that contact and to use what information they know about a standby guard.
Shouldn't that be child services problem, not?
I wish Child Protective Services were there and I wish they did something about ICE.
You know, I think the more I look at this, the more I'm actually comfortable with the House C, because the superintendent, no matter when it is, that school is going to do everything they can for that kid.
They are.
They're going to want to, and they don't care whether it's summer or those people are dedicated to those kids. And this is really just saying,
On the
do it as much as you can. Well, just as much as you can, help make sure this happens, that they get connected, and they're going to do it, whether it's summer, they want to do it. Whether it's on school premises or not. I mean, when things happen to a child who is in any school, the whole school rallies around them, and the family. And this is really just saying, help get them connected to services. Pretty basic.
It is.
So I'm actually okay with C, I've decided. But I think it's pretty, so let's move on and just getting through that.
Okay, so I was beginning to explain on the Senate side, the immigration resource guides was put in the session law, section 3. There was some debate about this is an ongoing thing, and usually if it's ongoing, it should be put in statute. So that's what the House did. The language is virtually the same, that the AG creates this guide that, you know, informs administrators about immigration and civil rights resources. They then give to students. None of that has changed. Subdivision 3 on the Senate side was moved to session law because it is a one-time thing. It must be done on or before August 1 and sent to all superintendents and head of schools later on in the House side by August 31st.
The House side did what?
The House side, it's the same date, but they added head of school as well.
Okay.
As well, superintendents. You know, it'll appear, I should have added it here on the House side, but it's later on in the side by side. Subdivision B of the House side, there was discussion about the AG typically does not communicate with schools, and they prefer AOE being the distributor of this information. So while the AG reviews the guide, creates it, updates it, they then send it to AOE for distribution to superintendents and head of schools to then distribute to their.
That makes sense.
Yeah. Okay, subsection C, student records on the Senate was reworded to student information privacy. Just kind of the same information, a few changes on the Senate side. The intro text was schools are prohibited from using policies or procedures to engage in practices that had the effect of excluding a student from school. They took testimony on this, and Julio Thompson from the AG's office suggested this might be a little confusing, and I think even some of the committee members suggested this could be confusing. So just kind of clarifying it by removing the words and adding school districts and not just schools, because they tend to be the ones that have the policies that implement the policies. So school districts and independent schools are prohibited from. One is the same. Two.
If I could, Mr. Chair, before you move on.
Yeah.
So here, I think approved independent schools is missing, the word approved. Was that by intent? Was that purposeful to not have the word approved independent school? Because our entire state system has divorced itself of care and feeding of non-approved Vermont schools,
Correct.
independent schools. So we shouldn't be directing them to do anything.
I think you're correct here. I think that needs to be either, school is defined to include independent schools, but independent schools is not cross-referenced. Although this is in Title 16. Is there a definition? Let's see real quick here. You have some definitions that apply to the whole chapter. I'm guessing this is not going to be one of them. Means a school other than a public school which provides a program. Okay, so yeah, it does not. And at the definition of independent school, it would need to be referenced to 166. So that would be probably a change we want to consider.
Okay.
Is unless you wanted to apply to non-approved independent schools.
What was the house intended to be just approved independent schools?
There's not an intent, that was not intended.
That was my point before.
Okay.
Yes.
Needs to be named approved if we have jurisdiction over them.
And I'll talk to Beth St. James about whether that should be just approved or approved pursuant to 166. I don't know the correct terminology there. Okay, so subdivision 2, designating on the set aside disclosing, just an important change that we're talking about information, and disclosing is a more, I think, real life use of that information, that you don't really designate, you disclose it.
Yeah.
So the prohibition is against disclosing that information. Subsection D, law enforcement on site, adding head of school, which is correctly associated with a approved independent school. Adding that a few times in the subdivision 1 and 2. And then subdivision 2, changing that last portion about the warrant. So on the Senate side, the subdivision ended with the officer providing official identification and a judicial warrant that names a specific individual under arrest or subject to a search. Rephrasing that to be a judicial warrant on the House side that authorizes entrance into a specific area of the school and names a specific individual located within the school who is subject to a search or arrest. This narrows the warrant requirement quite a bit, and this was what the House committee wanted to go with.
If I could, Mr. Chair, the section or the phrase that they appear to have really added is into a specific area of the school. The remainder of it's fairly consistent with the Senate language. And I'm wondering why a specific area of the school, is that common practice in warrants and such? As opposed to this is the school but this is the cafeteria?
Can be. I mean, I've never seen a search warrant for a school, so I'm not entirely sure. And that's not- But,
Just a little.
but I mean, search warrants are supposed to be quite specific, and where I don't know what type of testimony they took as to why specific area was. So can't speak to that, but I can say that as an underlying, search warrants are supposed to be very specific, and you're only supposed to search the area outlined in any warrant instead of going on a wild goose chase.
So if the
If I could.
individual is in a place where you're not specific, you can't go there and search. So if they don't know that says a named individual, I mean, they know who they're looking for. But if you say you can only go here and here, and he's someplace else, he or she is someplace else.
I think it depends on the situation. I think it's possible that you could, but it really depends. If in a different circumstance, if you have a search warrant for a house and an arrest warrant for an individual, and you see them run out to a shed in the backyard, and and you make
See
that
it, yeah,
observation,
the
even
probable
though
cause.
you most likely could go to the shed and grab them. But it really depends on the circumstance.
So the house narrowed to a specific area. Yeah, okay.
Yeah, I'd propose to strike out into a specific area of the school.
I agree.
Continuing in the same sentence, it says located within the school, a specific individual located within the school who's subject, blah, blah, blah. It seems like it's trying to create an unworkable scenario. I fully support the concept of what we're doing here. I just want to make sure that we're not kind of like repeatedly poking everybody in the eye with a sharp stick. Yeah. Just my thought, I'd remove into a specific area of the school.
Well, I mean, just to play it out, the real point of this bill is we don't want ICE in schools. We want kids to be left alone. And it's a little less likelihood of a wild goose chase if the specific area of the school is named. So I'd actually prefer leaving it in my part.
Okay, so I respect that. My point is only if this action is, if it's got the appropriate warrant, search warrant or what have you, they're not going to know if the individual is in the cafeteria or in the theater or classroom X. It's just not. That's not.
They tend to, I mean, school officials tend to have to know pretty quickly at the front desk, like what class they're in and where that class
Right,
is.
but the agents wouldn't.
Oh,
That's the point. I know that the administration may, okay, it's the agency who's ever wanting to conduct the search. If they've done all the legalese necessary to do it, they just simply don't know if they're in the cafeteria or in the theater. And if they list the cafeteria as a specific area of the school, but not the theater, it just seems like we're just trying to purposely create an unworkable scenario. That's my.
Senator Machine.
In this context, is school defined just as the structure of the building, or does it include the adjacent school grounds and the adjacent structures like stadiums or anything like that?
So it's not defined as either. It's just defined as a public school. So presumably it could be the school grounds.
If we said premises, does that cover everything on that?
For the warrant, so that authorizes entrance into the premises of the school,
Of the school
of the school premises.
yeah, because that, anywhere that the school, premises, would cover the whole footprint of the school, be it just the school building or all the fields.
That's, I think, one way to do it is to word it. If you want to broaden the scope to be, school property, basically.
Yeah.
I'm not interested in broadening it.
yeah.
I agree that we're here to protect the children, okay? However, if they've done all the legalese, as Senator Weeks says, the school should not be hindering if they have an actual criminal they're trying to get. 16 to 17 to
I feel like,
younger than that.
I feel like most of what you're talking about is hypothetical. In the well-documented situation that happened in the state, even local and state law enforcement will tell you everything that ICE did from start to finish was unclear who authorized it. They picked up no one or terrorized no one who had their name on the warrant. They caused a car collision. I would like us to err on the side of protecting public safety, especially in our.
And I agree with
We're not disagreeing with that.
Okay, well, if
They have all the
what
proper-
happened with ICE in our streets.
all
then
the
you might-
correct documentation, then we should not impede them. In this case, you said they did not, which, okay.
So I think we're actually, on that level, we're in agreement, I think, because the correct documentation would be
Yes.
the areas of the school that they can search.
Yeah.
Or the specific individual who.
Yes. That
They,
they're acting.
the front desk doesn't have to look at a piece of paper and say, I don't know who this person is, they are not here. And have ICE continue to push forward, which is what happened. Because it turned out, they had the name of someone, they were not pursuing at all the day that they came to an elementary school.
We've addressed
Say
that.
what the warrant says. And the warrant, if it's well drafted, should say the specific areas and the specific individual. And if it doesn't, then I've got, you know.
I was
I'm not-
gonna say something similar to you, Chair, that, you know, if you're doing your due diligence and you're taking steps as significant as going into a school to get somebody, you should know where they are. And if it's that urgent, you know, you will have presumably done the investigation and
if you
gotten
can get-
the information to know where they are.
And if you can get a judicial warrant that says the entire school, then that's what the warrant says. If it doesn't say it,
Yeah, but then the judge could push back and say, well, no, it says here by law, it must be a specific area of the school. What area of the school do you want this written for? That's the scenario that I'm trying to highlight. Are you in room 10 or are you in room 27? You know, well, we're in room 10 right now, but our normal assignment is in room 27. And if, you know, again, here the scenario is they've done all of the due diligence, they've got the judicial warrant, they've gone through the process, they know who the person is, and they're proceeding.
I think all this says though is that when they say they've gotten a warrant, the warrant will say where they are authorized to search. And if it says the entire school, well, then that's what it means. But if it doesn't, then I guess, you know, we don't want ICE cowboys doing whatever they want.
Everybody agrees with that.
Yeah.
Nobody's pushing back on it. Just trying to create a workable document.
So yours, just to make sure I understand, so you're just saying that if they have any kind of a warrant, they get access to everything?
I would simply like to strike into a specific area of the school. Still names the individual, still names the school. Obviously would outline the purpose and would have gone through judicial due process. I don't think it needs to be more complicated.
So I think you would say that authorizes entrance into the school. That names a specific individual. Is that your suggestion?
Yes, that's all I'm saying.
Well, let's.
What's what? Authorizes the entrance into a specific area of the school that.
And that names.
So Senator Weeks is suggesting that it read that authorizes entrance into the school and names a specific individual. He's suggesting crossing out the words a specific area of.
That's good. Thanks, sir.
Let me just ask the House if a specific area meant a lot to them. If they have more teachers
Yep.
on their committees.
You should, I mean, I don't want to beat this horse. We're talking about terrorizing the school.
Yeah.
And I just assume take any opportunity to limit the area of the school that gets terrorized.
Yep. I'm looking
Yeah,
at this like an active shooter on campus.
I mean, more so with the legalese, if a warrant says you may search the classrooms of such and such school, is that not specific? I mean, it would encompass all of the classrooms, but it is a specific area of the school, that being the classrooms. Or if you were to say on your warrant, you are permitted to search the classrooms and the cafeteria and the gymnasium. Those are all specific. It encompasses most of the school. But it is specifying the areas of the school that can be searched.
I think it's gonna be a judgment call, and I think that's one way to look at it, that you could say classrooms could be specific. Maybe depends on the size of the school as well, how many classrooms they have. Are there different wings of the school, different, you know?
I think in that sense, I mean, I'm fine with the way it's written.
I would just like to object to one thing if I could. So we're talking about a process here of the judicial system, which I fully respect. Conflating the term terrorist, terrorizing with the concept of judicial warrants. I know we're in a bad place in the US, but I don't think we're that far out. And I do take exception to, from a judicial perspective, conflating terrorism and judicial warrants in the same sentence. I'll just leave it at that. I think that's a bridge too far. We're trying to prevent the terrorism of anything with this language.
And still,
I meant the kids are gonna be terrified, and they will be. That's what I meant.
I do want to remind people, what we saw was people in unmarked vehicles with hoodies and semi-automatic weapons.
you know what would have held that ever from happening? Having the person be here legally, and it would have never became an issue. So I don't want to get into that argument. I don't want to get into that argument.
I'm just saying what I
That's
saw with
triggered
my
it.
own eyes.
That's what triggered it. I do not want to get into that. And it's bad day, and yes. Are they operating sometimes terribly? Not argue with that at all, but it's still the law. And we should allow, as long as they're doing everything under the letter of the law, judicially. I don't see how I'm with Sergeant Weeks, with Senator Weeks, that, you know, us trying to make it so it's nearly impossible. I don't believe should be our
We
intent.
have heard that our local and state law enforcement spent all of that day trying to manage a threat to public safety. And that threat to public safety was federal chaos and semi-automatic weapons in the hands of people who had almost no identification. That is a public safety threat.
But if instead of specific area, we said specific areas. And then we move on to the next section.
Okay, I'll take it.
Okay.
Just trying to soften this a little bit. I mean, everybody's kind of should not be a polarizing moment. We're all trying to get to the same goal, I believe.
And I think, one thinking about this, if it says specific areas and they're granted permission to search classrooms or the cafeteria or the gym, and they're looking for a 17-year-old male, they're not going to be also checking, girls' bathroom, for example, and, trying to narrow it.
The elementary school wing.
Yeah, or, if they're looking for a 17-year-old and it's a K through 12 building, they're not also going to be looking in the elementary school for the elementary wing.
Question, can we put in a discrete way, can we put in the law that they have to do it in a discrete manner?
The law enforcement,
Yeah,
this bill, would be a strange place to do that, because you're talking about law enforcement as far as.
I get, but I hear what the chair was saying and Senator Hinsdale is saying. That, you want them to come into, it's like come in a very discreet manner into the school to not even let people know they're there.
I think this bill, though, is about school officials and their relationship with, I don't think there's anything we
I
can.
don't think we can be prescriptive on federal tactics.
And maybe just something that I want to maybe make clear.
Do you really want?
No, I do. I think it's going to be helpful. We're talking about immigration related requests, civil warrants. We're not talking about criminal activity here. So there are times where you get a criminal warrant for an immigration matter. There are a couple of crimes that are related to immigration that would require a criminal warrant. This bill does not address that. These address, and it's defined, if you look at the next page, subdivision 4, what an immigration related matter is. So the likelihood any kind of warrant is going to be granted for one of these instances is very low. So just keep that in mind as well. But happy to draft up an amendment that fixes the independent schools as approved, and then the maybe changing area to areas is what I'm hearing. From the committee. Okay. All right, on to subdivision 3 on the House side, just addressing a cross-reference to the previous subdivision. And this is earlier I mentioned the definition of school, removing the people that work for the school. This is one instance where you had to add that back. No school or individual working at a school. The Senate version did not have that. It had school staff member, actually just had no school because school included employees. Shall reveal any information about a student or school staff member, and then adding the phrase unless otherwise required by law, just ensuring that federal law is not going to require some type of information request. No change to the definition of immigration related matter and immigration related request. On the Senate side, subdivision 5, on or before January 1, 2027, AOE, in consultation with the Vermont Superintendent Association, shall develop and review at least annually model administrative procedures for the policies that are in this subsection, the law enforcement on site. This has been delegated over into the model policy, and I'll reference that when we get to it. So it's not gone, but the details are not going to be copied over. You'll notice that the procedure shall provide a process to follow. That is not in the House version.
And the assumption is it will simply,
That it will be addressed in the procedures, correct? Subsection. Subsection E, immigration agreements. Understanding that sometimes it's not the school that enters into these agreements. It could be the school district or supervisory union, adding those other two to the definition in subdivision 1. Also striking the sentence, the school superintendent is the sole individual to approve an agreement required by federal or state law. There's at least one agreement that the governor must agree to, these 287G agreements. So there was concern that you didn't want that to conflict with existing state law. 2A and 2B. This is, again, because the superintendent or head of schools involved in this, but they don't make the decision. They review the agreement along with the AG's office. And then instead of approving it, they suggest either it be recommended or not to the school's governing body, whichever that would be, depending on if it's an independent school or a public school. So A and B are new, but that's because the House changed the decision-making process for those agreements. Subsection F, sentence was added that matched existing state law in the same area, that if there is some type of school policy that violates federal law, that policy is abolished. That was recommended by the Attorney General's office.
You say that again?
Sure, there is, on subsection F, there is existing state law language that has similar context to where if a state practice program is doing something that violates one of these two federal laws, that practice is abolished. Here, if a school is doing something that interferes with federal law, that school practice is abolished. It's conforming to another similar state provision.
Thank you.
Okay, next page, subsection G, policy required. So they still, AOE still must produce a model policy, but again, including the recommended procedures instead of just separating those out. The policy shall reflect the requirements set forth in subsection C and D of the section. So this is also a change. The Senate version, the model policy would have required the entire statute to be put in policy. And there was discussion that this entire statute does not require policy, that it's really C and D, which are the law enforcement on-site sections and the student privacy, the student information privacy sections. These sections on the immigration resource guide, the section on the agreements signed by the superintendent or head of school, those aren't really requiring policy. That's just very specifically things that will be done by those two entities.
Good. So I recall the Deputy Secretary of Education being in here talking to us about the differences between policy and procedures, et cetera, et cetera. And I don't fully recall the kind of guidance she gave us. My only recommendation is on that particular paragraph, make sure that the model policy and procedures is all doable by January 1, 2027. That's all. Because she made a point of differentiating between the two. And I think there was also a third category, guidelines or something to that effect, that's like a sequential rollout. And I don't remember if this, this potentially would hit a speed bump or take longer. But just my only recommendation is have AOE at least comment on the doability of the paragraph.
So you're just saying, so your question is really, can they do this by?
Can they do it? Yeah, just because they've added the word procedures and that wasn't in there before, I just want to make sure it's
Well,
doable.
I mean, I'll just say what we heard from them was that they very quickly turned around guidance after Minneapolis. That was like two-page guidance to school. So this probably does need to be done quickly, and they have shown that when a public safety risk like this is imminent, that they were willing and able to turn that around quickly without being asked by us.
Yeah, I acknowledge that. I just,
That's not my answer.
I think that we have, we're not out of runway completely to be able to make sure that what we vet here is executable.
Well, I'm going to assume they're watching. And invite the agency to let us know that the current model policy recommended procedures by January 1 of 27 is or is not an issue.
I mean, I would say that everyone has spent everyone involved in what happened on Christmas Street on March 11th has spent considerable time since then thinking about what the right procedures should be. I hope AOE is already doing that because other schools may face this situation. So I would imagine this is something they should be able to do.
Agree, just, I'm hesitating to commit on anybody's spec.
So
There's only one more change, Mr. Chair. And that is the effective date. So on the Senate side, it was July 1, 2026, and the House side on passage. There's a little bit of discrepancy I mentioned earlier about the sections 3 because some of the language moves in the statute because it's an ongoing obligation of the AG to update that guide.
So we have the changes as far as I remember are the clarifying the independent school thing. And specific areas. And well,
So I was reminded that all independent schools that operate in Vermont that have a license to operate fall under the 2200 series of rules. So generally, when we are talking about rules and legal guidance, we are talking to all schools that are licensed to operate in the state, not just the ones that were.
I actually don't know how that plays out. Well, so I think, by the way, I'm fine, but the whole point is we want schools to be that, no matter what they are. So. I believe the school, the term independent school, only to those receiving. Because it's kind of like approved for tuition, for receiving tuition, but. Which does mean there's a lot of other independent schools in Vermont that would fall outside this category. I think they want to do this. I don't know.
Right, I think they would too, but are they obligated based on the fact that, we've kept them more than an arm's length away via policy for decades?
Let me have, Rick will check with Beth about exact what that actually means and what it doesn't, and we can take it from there.
And it's just the student information section too. That's the one, the student records. That's the one area where it's just independent schools without being clear. So that would be, the disclosing information or sharing it with someone else.
So
If I could, just because I know we're trying to wrap up this 227 bit. Going back to the second page, the top paragraph on the right, well, actually a couple paragraphs down, but connecting the student with the student's family. I think we did at least talk about, instead of student's family, given the generic nature of the word family, that it be changed to parent or guardian. We kind of skipped over, it was mentioned, but wasn't mentioned in the summary. And I'm okay with that. But I do hesitate about the fact that, and I do recognize that our schools and our superintendents, staffs are magnificent. I just caution that we're obligating the superintendent or the head of school to become responsible for connecting the student and the student's family with immigration advocates. I think that the responsibility ends with the student, not the student's family, or excuse me, parents or the guardians in this case. The student, yes, and it should be a handoff. I don't think superintendents are trained for this type of environment, and they need to basically shift responsibility to a different agency, whether it's DCF or whomever. But in any case, my perspective is simply that we should be focusing on the student, not the parents and the guardians in this case. But I'll leave it at that.
Chair Barnett,
yes,
I'd like to say something about the search warrant again. And I don't know how many search warrants any of you've been on. I've been on a few. And to tell somebody that they're going to go participate in a search for an individual, but you tell them they have to be restrictive in where they can go, that puts their lives in danger. Because even though, somebody just moves to a different undesignated area, and it puts that team that's doing the search in jeopardy. So I'm in favor of leaving it the way the Senate has it, and I reject what the House put in there.
You know that the person that you're seeking has moved to another area, you can still pursue them.
Well, that's not the conversation I just heard.
I did mention that a while ago at the beginning.
They use the shed analogy.
Now we have areas.
Well, if you see them run into a different building, you have probable cause to believe that that's the one you're looking for, right?
let me just posit this. I don't think there's anything in that language that prevents a judge from saying the premises, that's specific. If that's what the judge decides to do, then that's what it is. There's nothing that says the judge. It's just the judges are going to tend to be as circumscribed as possible. And if that's what the warrant says, then that's the only areas to which they gain access. If the agents are able to convince the judge, say the premises, buildings and grounds or whatever, that's still specific.
I think we're just causing our own problems if we allow the language that's in there to designate the people that are trying to enforce the policy that come up against these individuals that have jurisdiction or have the authority to do what they're doing. We're creating an environment where there's going to be conflict instead of deconflicting it. So therefore, I think that it's not a good idea.
Well, we're really talking about ICE trying to come and get a student. Not talking about a dangerous situation.
And we're also talking about many schools that have co-located elementary, middle, and high school facilities.
And again, it's just following what the warrant says.
Yeah.
Making clear that the school follows what the warrant says. You've been around this.
Yeah, I don't.
Right,
have any
I
issue
trust
with
a
it.
judge to,
Yeah, the judge will say.
yeah.
If the judge thinks it's appropriate to say buildings and grounds, then that's what the judge will say. If the judge thinks it's appropriate to say the southern wing, because of where the high school is, then that's what the judge says. Yeah.
We do need to think about the superintendents. They're the ones that are gonna be seeing the warrant. They make the decision whether or not to allow the officer, right? You have the ID, you have the warrant, and if I'm a superintendent, not a lawyer, I look at a warrant that says if there's no location, sometimes the arrest warrants don't have any location, right? And then that's a pretty easy call. There's no, you can't come in, right? Because you don't have access to the school. But if it says, if a judge issues a warrant that says into this XYZ school, if I'm a superintendent and I say, well, the law says into a specific area or areas of the school, to me, I don't know if I would agree that a school is a specific area. I might say, well, I think this has to be a room or a classroom or I think we need to think about, it's not a judge reading these when they come to the school. It's going to be the school administrators, and maybe need to be intentional on what you want to do. As written, it's going to be very hard to have a warrant that looks like this. That's going to have a specific area in the school, which I think sounds like is what you want for an immigration warrant.
So, let's think about our objective here, which is, so my objective when thinking about this is to simply make clear that the school officials have to allow the agents only into whatever the warrant says. Right? Warrant says the premises, it means everything. And that's what I don't know. So you're saying that the way it's written, it could put the superintendent in an impossible situation because the warrant will likely not be that specific.
Right. It could be, like Senator Hashim said, they can be specific, especially if it's a house warrant. But if it's at a workplace, I don't know how specific they would be.
Well, since, I guess, this is a judiciary question, and that since we are talking about an incredibly sensitive area, can we ask the judge to be very specific in the warrant?
To me, that's not the issue, Senator Martin. So the issue is the superintendent reading the warrant, and if you write a statute, however you word this, the superintendent head of school is going to be reading it, presumably in the policy, right, that AOE makes. So the policy will be what they look at. And I think you all, as lawmakers, need to be clear about what you want to prevent or allow in this case. And maybe it's you don't want to allow, because the way it's written currently, I think it's going to be very difficult for law enforcement. And I said this on the record in the House, it's going to be very difficult for an officer to have that type of warrant for an immigration related matter. It's not common.
Say, what type of warrant?
So we're in the world of immigration related matter,
Yeah.
which is a civil warrant. It's basically, it's mostly going to be ICE.
Right.
They don't really get criminal warrants. They get civil warrants that have someone's name
Yes,
that are not allowed to access non-public area. It's usually,
right.
you have to get permission from someone to go into your house or go into a business.
Mhm.
In this case, you're saying there's never going to be consent. You have to have a warrant to enter into the school,
Mhm.
right? So I think my point is that if it's a non-lawyer looking at these, you just need to be clear on what the warrant needs to say for the person to let them in.
What if we said that authorizes entrance into the school or limited areas of the school if specified in names?
You need the or if you have the entered the premises of the school. Isn't that,
Well, I was saying, included that if it's, well, you know what, the superintendent's, the guidance would be. I'm thinking if the judge did do, saying the southern wing, you only want to let them in the southern wing. So I was thinking of, you're saying it's going to tend to be general into the school. And the only thing I was thinking about is adding or limited areas of the school if so specified. And names.
So I don't know if this is changing what people are picturing or considering, but I think I heard something that I'd like to question further because I don't think it's accurate. We haven't seen warrants for children. We've seen warrants for a parent taking their child to drop off or pick up. So I actually don't think that warrant was designed to allow ICE onto school premises at all. They were discreetly lying in wait in the parking lot and went to grab the parent as they dropped their child off. So, and then that person fled and they pursued them down a busy street and thought they had pursued that person, that they never were pursuing the right person, into a nearby home. So I don't think we're trying to allow them to have warrants for children. I think they would enter school premises if they had a warrant for, God forbid, but a teacher or parent. And we should probably limit their entry into the building at all. Like, they should not be there interacting with children. There's
What we're trying to do.
right.
So
I just want to make sure we're clear, like, there's no children's warrants this point.
so far.
My understanding was a while ago, there were at least 4 of us that agreed on the phrase specific areas. Is that no longer?
Well, it's like
I think council's word, that's gonna create problems. I guess I'd be comfortable going into the school.
Council, is it, if being that this is will be a federal warrant, would anything we say really have any impact in this law?
so it could also be a state warrant. This applies to all law enforcement, right? So the federal warrant, federal employee, ICE agent comes to the school, the superintendent will still request the warrant, right? Because the law says you must ask for ID and a warrant. So it would be then up to the law enforcement official if they would want to abide by the instructions of the administrator.
So I guess my question is, we may be, it obviously will affect state law. But if it is ICE per se, with a warrant, does this law have any jurisdiction over that?
If they have a criminal judicial warrant to enter,
Federal,
yes, with this law,
this, what we're writing right here,
it
right?
would be allowed to enter. So if they had a warrant that had a specific area for a specific person, at this school, they would be allowed to enter.
I understand, but would this law have any effect on it? Being it's a federal law, that's,
Well, it had an effect on the superintendent and that, or head of school issuing that decision. And like I said earlier, if the law enforcement disagrees and they enter anyway, then that's a different problem.
okay.
But a federal warrant or not, if the warrant said northern wing only, then you could at least attempt to lock them out of the wing. And if they broke down the door, they break down the door, but, with or without the warrant, but. So I think we're down a rabbit hole here, and we just need to figure out, what we're really saying is the warrant controls, I mean, the warrant says what the warrant says, and we just want it to be confined to the specifics of the warrant. We're just trying to figure out how to say it. So maybe you could. Maybe that would be.
I'm looking at the Senate version, how you all worded it. It was a specific individual on, it wasn't worded correctly, as Senator Hinsdale caught me after third reading and told her we fixed it on the House side, we fixed it, Senator Hinsdale. But so the Senate version was basically a specific individual subject to a search or arrest. So it was much broader. The House narrowed it quite a bit.
Yeah.
Maybe find something that works.
Well, let's just think about it.
Okay.
So we can shift gears to page 650.
Okay, let me get that up. So draft 2.1 should be posted on the webpage.
Yeah, hard copies.
Okay,
Which one?
650. Somewhere. Underneath your, so.
Nope. Now let me see, Terry should have got it.
okay, I have my screen shared too, Senator. Not many changes to this draft from I think it was 1.1 from a week or two ago. So no change to page 1. Again, just to remind everybody, this enforcement language is in a different subchapter. This is a technical correction. This is not part of the substantive portion of H650. Page 2 is where the substance begins. This is the educational technology registration, which I need to strike that word enforcement, which I will do on the next draft because the enforcement has been removed from this section. You may remember the committee met on Monday on Zoom to discuss this bill, and there was debate about the enforcement mechanism through the Vermont Consumer Protection Act. So it was subsection C, enforcement, that has been removed from the bill, and there's no other changes to this section. So you still require ed tech providers to register with the state, which would give the state more information about these entities, what they do, their products, that they meet the standards set forth in state law already, kids code and student privacy standards, but there would be no enforcement if they fail to register with the state. Section 2, this is the chatbot prohibition. The change highlighted, it was a 5-year prohibition, now would be a 2-year prohibition. Subsection A, intent language has been added. Again, this is in session law, so it's this can be amended however you want, this intent language. It is the intent of the General Assembly to replicate within the education context the thoughtful and deliberative approach Vermont previously took regarding the use of artificial intelligence in state government. Chatbots have been known to cause children to engage in academic dishonesty and to suffer from mental health harms like addiction and suicidal thoughts. Therefore, the General Assembly enacts a 2-year pause on the usage of chatbots in schools to provide schools with the opportunity to research, test, and endorse certain technologies to ensure the safety of students. The prohibition, it was 2031. I'm trying to do math in my head. It is now 2028, making it 2 years. Subsection C, there are still
In there, as far as that goes, but if the school has vetted a chatbot use, because we've heard from a group that have been using it, it will be allowed, or is this?
So maybe coming up. Yeah, we'll see what you think about the exceptions. So there are exceptions in subsection C. A school principal or head of school shall have the authority, and previous language that highlighted. Shall have the sole authority, and I removed sole because of subsection or subdivision 2 coming up. They shall have the authority to grant an exception to the prohibition, provided the chatbot is strictly necessary. The previous word was used, the recommendation was necessary, making it very narrow for educational purposes. The principal or head of school shall track any and all exceptions made to the subdivision and provide a list to AOE. The list shall include the name of the provider of the chatbot along with an explanation of the educational purposes of the chatbot. So that's one, it'd be up to the administrator to make that exception, and it must be a very narrow educational use purpose.
Should the principal or whoever the authority member have to get verification like the school board?
I mean, amazing, I'm glad we're talking about strengthening this section. I feel like they could be asked by the school board, why is this, retroactively? I think it would probably be kind of a new wrinkle in school governance to say, like, you have to get curricular approval on something from your school board. I think.
You understand my worry.
Yeah.
I'm just having one person be the sole, making the sole decision.
I think because you need to be able to go to one person and
I-
say, who authorized this?
I can live with that. I just wonder why we're not, having it.
Like a double two-factor authentication.
Say, well, take us for instance.
Yeah.
You might say, oh, I think this thing's great. And then I turn around, I don't think it's that great.
Mhm.
But you
I
were the
hear what
sole
you're saying.
person to decide that.
Yeah.
Where's the checks and balances that one of us has made the right decision?
I mean, I guess, like, we've heard from some of the stakeholders. We've gotten emails from them, and I think what I heard is this is happening.
Mm-hmm.
They're erring on the side of letting it happen. And this is saying, we're gonna hold you responsible if you kind of casually made that decision. So I guess the check and balance is that there's a lot of people in the classroom and the school building who are making the case for using these technologies, and the school board, if they hear complaints or concerns, should have one person that they could go to with sole decision-making authority.
Okay.
That would be they're not gonna be in trouble, and maybe casually that teacher or IT director goes to the superintendent and says, I think that was a bad call. And they have a conversation about it. But I just think we're trying to locate the responsibility for approving this in one person so it doesn't proliferate with nobody taking responsibility.
And you're saying she's the principal for that school.
I do think so, yeah.
I can agree with that.
Subdivision 2 is straight from Act 72. That includes as many things, the cell phone restriction that you passed into law last year. This is specific to chatbots. A school may allow the use of a chatbot for a student if such use is required as part of the student's individualized education program or 504 plan, which shall be documented according to applicable state and federal law, provided if that such use is required to meet an international student's special education needs or as part of a disability accommodation, and the international student does not have an individualized education program or 504 plan, the need for such use shall be documented in a manner the school deems appropriate.
So that's right out of the other statute, okay.
My understanding that meets the accessibility requests. That's my understanding. I don't know for sure, but that's the attempt to meet those exceptions. And that would not be a decision of the principal. That's why the principal has the authority under 1 for that. For number 2, that's a different process, I imagine.
Did that change come from the House?
No, it's
Or-
highlighted because we wanted to make sure we got the
Well,
language right about.
The entire section, this section came from us.
Yes.
The Senate. This came in after the House.
Oh, okay,
The highlight is new today.
Yes.
Or
This is a strike all amendment to the House's passage of H650. No change to the definitions that chatbot or a school. Chatbot is, again, still fairly broadly defined. AOE still must provide guidance on or before, notice and guidance on or before August 1 of 2026.
Yes.
So I'm on the exceptions part on page 4. And I know we've heard a little bit about this, but why are we making principals or heads of school provide a list to AOE? Like what purpose does that serve aside from it? It just kind of seems like busy work that we're putting on the principals, and then AOE says, all right, thanks for the list. And then what?
So policy choice, right? You have a prohibition and these are exceptions to the prohibition. I don't know if you want that stored for when the prohibition's over, if you want to somehow certify them or address the governance in some other way, but certainly you can remove that, change it.
Yeah, I mean, I don't think. I don't know why it's needed. I mean, I feel like. I'm going back to some of the conversations that we've heard earlier on, both this year and last year, just about administrative burden that we put on teachers, principals, and superintendents, and just the stacks and stacks of paperwork that they have to do. And I don't know, it doesn't seem, you know, it's creating this list and then sending it to AOE, and then what happens
Yeah.
after that?
Goes into the complex.
it could be a vestige from when we had AOE doing something. And they repeatedly said they're probably not doing anything.
So I'm with you.
And
So I mean, our point here, I think, as I understand it, the big point is we want the starting point to be no for 2 years. But if the principal head of school says, yeah, it makes sense, because we heard some testimony about it being used in a way that's productive, then the principal or head of school can say, yes, that's all we're doing. That's it. That's what we're trying to do. So, yeah, we don't need a little busy work. I agree.
And the other piece I wanted to ask about is on line 11 regarding strictly necessary. Just wondering why we have the qualifier of strictly necessary rather than just necessary, because it's either necessary or it's not.
Fine.
I'm always good with taking qualifiers out.
Yes. do you have anything else?
I did. I do. Yeah, I'm still pushing back on the whole chatbot prohibition. Talking about, you know, unnecessary bureaucracy and what have you. I trust the educators. I think that we had enough testimony that that they understand, they seem to understand the tools that they're using, and have them vet the academic utility while this working group forms and evaluates technology with a bigger aperture. I just think that we're complicating the use of a fairly common tool now and increases the issues which the administration and the teachers have to deal with. I think they can handle this. I think they are handling this appropriately.
I don't know if we want to get into a debate about it.
Well, straw polling, I'm just saying I'm not in favor of the section. That's all.
Okay.
So
okay,
I don't.
No, I don't, then I won't.
No, it's, I mean, we can have a discussion. And I am on one level, if I had to choose, I'm with Senator Weeds. But I got kind of comfortable with this because it's just that the starting point is no. but it doesn't, but if the principal at a school says, yeah, then that's it. And so they will have access. It's just a little bit of.
Is that a true statement, being it says individual education? Yeah, I guess it does because of the individual education program or a 504 plan.
I would be against a blanket prohibition. But with the ability for the principal at the school to say, yeah, it actually does make sense. They're not. I came around to being okay with it. I had the same starting point, 7 weeks.
I think,
No.
I was also just gonna say, I mean, I think we've also widened the scope a little bit. By one, reducing the administrative work they have to do regarding AOE, and also taking out the word strictly.
Mhm.
But I mean, we're talking about a new and emerging technology that changes exponentially every couple of weeks. There should be some, checkpoints that they go through before it's being provided to our kids for educational purposes.
It is, it's the teacher. That's my point. Teachers already vetting it. Students don't just use this in the classroom of their own volition. It's academics.
So I want to go back to, I think Senator Hershey was making a good point that I was also going to make about how we define a chatbot. There are a lot of instances at this point where even I don't realize I'm talking to a chatbot. That we should be really clear about. This is someone potentially impersonating the likeness of a human. And I've said this in healthcare before as a tangent, but the biggest killer in this country isn't alcohol or tobacco, it's loneliness. I think this is a very new frontier of kids who are vulnerable. They're mostly online. They're receiving record suicide, depression, etc. And we should know more about this before it is let loose on our kids in our schools.
Okay, again, though, we're talking about an academic setting, not like a social media after school boredom kind of endeavor. We're talking about academic programs driven by professional educators who are licensed.
I guess I try to not deal in hypothetical, and that's why, thank God, no school reported having a contract for Inanimate Alice, but that is a program where you are somebody interacting with a chatbot as your main friend. I want a school to have approved that they think that's educational before that's offered to my child.
Mr. Chair,
Yes.
if I could say something, this goes back to what I said back when we were having the debate about cell phones, is that if you want students to be able to exist in a technological world, then we need to build a curriculum that shows them how to properly use it. We haven't done that yet. And these are dangerous to children's brains. They really are. And we need to make sure that if we allow them to use them, particularly in a public school or environment, that they have guardrails that they have to keep, and we got to make the educators responsible for setting those guardrails and keep people inside them.
Okay, so at the very least, the part we know we agree on is the striking the strictly and the rest of that paragraph. And we can continue this discussion. We're not done, but we can at least narrow it down in the next draft. So then we go on to.
There's just really one more change in this draft. It's in the working group. You may remember there's a ed tech legislative working group made up of 6 legislators, 3 from each chamber. The one change is on page 6? Page 6, line 15, because of the chatbot prohibition. I think it might be a good idea to ensure that the working group is specifically reviews chatbots in their ed tech certification process, determining if those should also be certified or not. That's something I added because I thought it made sense, but happy to remove that if the committee doesn't think it makes sense there.
And can I add one more thing to that?
Yes.
That last week I mentioned that I wanted to put the opt-out in the miscellaneous ed bill, and I was told that it needs to be in this bill. So, and I think Beth St. James is going to go back and find the language that we had previous to that to make sure that the language for opting out was appropriate and accurate. Anybody remember that?
I remember you bringing it up, and I think you're also right that if we were gonna do it, this would be the place.
Did you want it in the study or Senator Williams? You wanted us to consider the opt-out?
I want you to
Right.
consider putting it in this bill so that parents can have their children opt out of it.
Yeah,
Okay.
well, but
It's an opt-out of all
yeah,
tech?
Let him articulate.
Senator Williams, what do you mean exactly? Do you mean all technology?
Yes, all technology.
Um, I think we could I'd be willing to have that be part of the study in some fashion. I think it's really, though, because we would have to take a lot of testimony to understand the impact that would have on the ability to teach a class. Half the kids are doing it, half aren't. You know, how does that work?
Yeah, like are we requiring printouts of things? Like, I mean, there are, I don't know, my brain is letting out.
I understand the point, but I think I'd be willing to go with having something like that be included in the study, but I'd be very careful about doing it without a ton of testimony.
I'm with the study, but I wouldn't want to put it in as an actual mechanism.
Yeah, I would support the study too, but I think it would be appropriate to ask Senator Williams if that satisfies the itch.
Yes,
Okay. That's good.
that's the best I can get
Yeah,
to put in a study.
we do need to talk about what this is. This is I might have an email from somebody about this, but it's like, are they opting out of ever being asked to use a screen in the course of their school assignments?
That's the intent, unless you have a curriculum so that the student can learn it the right way.
But like someone might have a like a desktop or something, people are getting,
Don't study it.
okay. I mean,
Yeah.
I'm looking at Rick, cause
So the idea is to study a parental opt-out of their student, of their child using technology in the classroom?
Yes,
Okay.
okay.
and
Like
we
you
did
can
have language in the original cell phone bill
No, like,
provided
gotta read it. I can't.
provided for that opt-out.
I have other questions going back to the beginning. The registration part. Never really got my arms around what happens with like technology that's ubiquitous, like Apple, whatever. Do they have to register just because they're the underlying platform in which everything is built? So are they educational technology?
So, I guess that's Alphabet, right, that owns Google, I think is the way that's structured. Whatever entity that they deem is the provider of Google Classroom or whatever the application is, they would need to register as a entity doing business. And then signify that they're an ed tech provider and then give the information that is in this bill, which is a link to their privacy policy, a name of each product that they, ed tech product that they provide, which are known to be used in schools, you know, the things that are in the bill. So yes, these big companies would also presumably have to register if they're not already, but now registering with this information.
And for specific parts of what they do?
So yeah, the way this would, I think, work, and we just did this with a franchisor bill that passed a month ago, where if you're a business, if you're a McDonald's franchisee, you would register as, maybe your name is XYZ LLC, but you're a McDonald's franchisee. So you'd register as XYZ LLC, and then you signify that you're a franchisee and that your franchisor is McDonald's. That's a very easy one. This one would be that you're XYZ Corporation and you are, and here's all your information, your address, a link to your privacy policy. It would be part of your registration as a business in Vermont.
And if I may, I was fielding a lot of concerns, and there's now no enforcement. So similarly to most of what's on the business registry for the state, quite literally, like, OpenAI isn't on there. That they are getting to self-define, and right now there's no enforcement mechanism if we feel they've done that incorrectly. I think we're having this similar debate in economic development around the California Data Privacy Act and delete functions. These registries all become more potent if there's a penalty for not being on there.
I think the census seems to be that.
To wait.
That emerge, yeah.
Yes,
Yeah.
to see
Okay.
what happens organically, and to work with the Secretary of State's with this task force or whatever it's called, the legislative group, to see the user experience that they're creating in this contract.
So do you have Rick, you have enough?
So I need to add, the Senator Martinez reminds me, there was previously language about the registration when AOE was doing the study, that they were going to communicate with the Secretary of State about the registration and to figure out, do we have a gap as far as number of entities operating in Vermont that aren't registered? With the legislative working group, that's not in there. So if you want the registration system to be part of the study, I would also look at the date. They're gonna wrap up by the end of the year.
That's not gonna-
You're not gonna get many
Yeah.
entities registering. You can still talk to the Secretary of State about
Yeah.
future of this system and how to better build it, but I don't.
Is there some reference there about that?
No, but I can add something
Yeah.
extra. Okay.
That makes sense.
Yeah.
Is everybody brain dead?
Hmm.
Okay, yes, okay, we can.
If you need one more brain cell.
I'm great. I'm great as
Okay, want to make sure everybody's sufficiently brain dead, okay. We'll call it a day.
Oh, we will? Are we voting?
Oh, no, go.